Swayam Prabha. Digital India. Educated India.
Hello friends, this is lecture 18 under the course Law relating to Women and Children. This lecture 18 is prepared on the topic Protection of Children from Child Marriage. Child marriage is a social evil, it is a social vice which deprives the children from their very basic and fundamental rights like right to personal liberty, right to education, right to development and right to care also. When a child is married in very early age, then it becomes burdensome to that child to bear the pressure of the parenthood, to bear the pressure of the responsibilities of the marriage and family. The child marriages are also contrary to the basic conception of the marriage itself. The marriage should be made at the mature age when both the parties to the marriage, that is the bride and bridegroom, are sufficiently mature to share the burden of their own and the burden of the family responsibilities. The development of the children is directly related to the development of the country, and therefore, the child marriages, when they deprives the children from their basic right to education, right to development, these child marriages also restrains the national development or the development of national resources. The development of national human resource is also restrained, and such this is the restraint on the development of the country. So, the child marriages are very harmful for the children with respect to their personal rights or the rights of their own. On the other hand, the child marriages are also very harmful for any country to develop. The child marriages in such a way impedes the development of a person, of that child who marries at early age, and it also hampers the national development. The lecture, this 18th lecture on the protection of children from child marriage, is also divided into 4 parts: introduction, the international mandate, the legislative initiatives and the judicial approach. Child marriages kills the innocence and childhood of the child and forces him/her to endure the warranted burdens of life at inappropriate and inadequate age. This early age is not appropriate age, it is not adequate age to share or to endure the burdens of life, and therefore, the child marriage, it kills the innocence, it kills the childhood. It restrains the developmental opportunities of the child like education, personal development, employment, etc. Child marriage becomes the cause of early parenthood, which is very burdensome and a health havoc. It restrains the human resource development of the nation. It creates problem for government entities to manage population control and establish relevant public policies. Child marriage is also responsible for the increasing population in the country. The increasing population, now it is becoming day by day a big challenge for us to manage or to tackle with. The child marriage increases the vulnerability of females for domestic abuse and offences. When the females or the girls, they are married at very early age, they are not sufficiently mature to understand their responsibilities at the new family. They are not sufficiently mature to orient themselves with the new environment of the new family. They are not sufficiently prepared to take the burdens of the responsibilities of the new family, and therefore, such females or the girls who are married at early age, they become the subject of domestic abuse, they become the subject of exploitation, they become the subject of different kind of offences against the women. In this background, the Law Commission of India, in its consultation paper on reforms of family law in 2018, the Law Commission of India presented a consultation paper on reforms of family law in 2018, and in this consultation paper the Law Commission of India remarked that a child remains a child whether she is married or not. When the child remains the child, whether she is married or not, whether he is married or not, then we can understand that how that child can share the new big responsibilities of the family and the husband. Rajya Sabha 13th report on the prevention of child marriage bill 2004, in its para 10.4 pointed out that a girl child had to suffer irreparable losses due to biological factors and inability to sustain pressure of marriage at an early age. This is very challenging, very remarkable, very alarming situation which has been pointed out by the Rajya Sabha in its report, that a girl child had to suffer irreparable losses. It means that such losses are suffered by the girl child when she is married at early age, which losses cannot be repaired later. And why they are to suffer these losses? Due to biological factors and inability to sustain pressure of marriage at an early age. At this early age, they are not biologically prepared for performing the obligations arising out of marriage. They are not able or they are not capable of sustaining the pressures of the marriage, and therefore, they are to suffer irreparable losses. In 2015 report of Law Commission of India, it was put forward that the prevalence of HIV infection is highest in women aged 15 to 24 and peaks in men between 5 to 10 years later. So, this data or this indication by the report of Law Commission of India in 2015 also suggests that there may be more chances for being HIV positive if the marriages are settled, marriages are made at early age. As per 2011 census, the percentage of child marriages in India are 31.6%. See the situation that the Child Marriage Restraint Act was enacted hundreds of years back, but still 31.6% child marriages are being solemnized in India. This is very alarming data. 31, one-third, at least one-third, near about one-third of total marriages. child marriages are held. Adolescent fertility rate for women is 15 to 19 years is 43% as per NHFS 5 report. National Health and Family Survey report number 5, NHFS 5 report. It shows that adolescent fertility rate for women is 15 to 19 years is 43%. 43% of the women 15 to 19 years, this is the fertility rate. Women aged 20 to 24 years are married before the age of 18. 20 to 24% women are married before the age of 18, though the age of 18 was prescribed as the minimum age for the marriage of a bride. Now it has been increased to 21. Despite this legal sanction, despite this legal restriction that before 18 the girls should not be married, 23.3% girls below the 18 age are married. Men aged 25 to 29 years married before age 21, which is the age of marriage under the laws, 17.7%. 25 to 29 years married before age 21 years are 17.7%. So, before prescribed age the 17.7% males and before prescribed age of marriage 23.3% females are married. In 2021, the Prohibition of Child Marriage Amendment Bill was introduced in the Parliament to create equality in age of marriage for both male and female by increasing it to 21 years. As I earlier also mentioned in some lectures about the minimum age of marriage for bride and bridegroom in different laws, that was 18 years for the bride for the female and 21 years for the male. Now, after 2021, the amendment has been made in the Prohibition of Child Marriage Act and increase the age of the women or age of the girls, age of the brides to marry has been increased to 21. Now, this is the equal age for both the bride and bridegroom, that is 21. What is the international mandate about the protection of children from child marriage, as the child marriage is contrary to the basic conception of the rights to the children. The Convention on the Rights of Child 1989, Article 19(1) of this convention CRC is very significant convention recognizing the rights of the children, and it was agreed to, it was adopted in 1989. When this Convention on the Rights of Child was recognized, the state parties became obliged to make the laws or to amend the laws in their countries in accordance with the commitment made under this convention. Article 19(1) of this convention provides that state parties shall take all necessary measures, including legislative, administrative, social and educational, to protect the child from all forms of violence, abuse, neglect, exploitation, while the child is in care of parents or legal guardians or any other person. Child marriage is also the exploitation of the children. It is also the violence to the children. It is also the abuse of child for the purpose of marriages. It is also the neglect to the basic rights of the children if the child marriage is solemnized. During the age when the person is in the childhood age, during that period, he or she is always in the care and protection of the parents or legal guardians. and therefore, this is the obligation of the state parties to this convention, that CRC, that they should make the laws for prohibiting the child marriages, they should take the administrative initiatives to enforce the law prohibiting the child marriages on the ground or in reality, so that such abuse, such exploitation of the children for the purpose of marriage or such neglect to the rights of the children can be remedied. Under Article 19, Clause 2, the Convention requires the state parties to lay down proper measures as to legal and judicial mechanism, so that child victim of such violence, abuse, neglect or exploitation can seek legal redressal. So, the Article 19(1) recognizes this right of children, that they should not be abused, they should not be neglected, they should not be exploited, there shall not be the violence against the children, and if any such incidents occurs, then they should have the legal remedy or the legal redressal. For this purpose, Article 19, Clause 2 imposes the obligation on the state parties that they should take the legislative as well the administrative measures. They should develop the administrative measures, they should develop the judicial mechanism, so that child victim of such violence, abuse, neglect or exploitation can seek legal redressal. Then the Universal Declaration of Human Rights 1948. Article 16(1) of the Universal Declaration of Human Rights says that every man and woman possess equal right in marriage in regards to the continuation of marriage and its dissolution. Men and women of full age without any bias have the right to get married and form family. This Article 16(1) recognizes the right of a man, the right of a woman equally with regard to the continuation of marriage or the dissolution of marriage. So, both men and women are entitled equally to the right to continue the marriage or the right to dissolve the marriage, meaning thereby right to marry and right to divorce. Both are equally entitled, there shall not be any discrimination on the ground of the sex, that only the men are entitled to take the divorce, the women are not. Such right has been recognized by the Universal Declaration of Human Rights by way of Article 16, Clause 1, that all men and women are entitled for their right to continue the marriage or for their right to dissolve the marriage. One important aspect of this Article 16, Clause 1 of UDHR is that men and women of full age without any bias have the right to get married and form family. Right to get married or right to form the family has been given to the men and women equally, but this right has been conferred only on those men and women who have attained the age of marriage, full age without. So, if they have the full age or they have the qualified age, they have the eligible age of marriage, only then they have the right to get married and right to form the family. So, the persons, the men and women who are of the age of the marriage are entitled to the right to be married and right to form the family. Under Article 16(2), it is provided that marriage should be contracted only with free and full consent of both prospective spouses. Two aspects of this provision, that is Article 16. In 16(1), it is provided that the men and women of full age are entitled to right to get married and right to form family. And 16(2) provides that marriage should be contracted only with free and full consent of both the prospective spouses, meaning thereby that men and women, the bride and bridegroom, the consent, free and full consent of both is required for the solemnization of marriage. And we know that a minor cannot give the free and full consent. Under the Contract Act, under Hindu Marriage Act, the minor is not allowed to give the consent for marriage, or the consent being given by the minor is not considered to be the free consent or the full consent. It also means that legally, any person who is below the age of majority is not entitled to get married, because he or she is not capable of giving free and full consent. Then International Covenant on Economic, Social and Cultural Rights, that is 1996 Convention. Article 10(1) of this convention provides that marriage should be contracted only with free and full consent of both prospective spouses. Again, the same provision has been reiterated by the ICESCR. Then International Covenant on Civil and Political Rights, ICCPR, 1996. Article 23, Clause 2 talks about right of men and women being of marriageable age to marry and have family. The same provision which was under Article 16, Clause 1 of UDHR, that men and women being of marriageable age, men and women who have attained the age of marriage, they are entitled to marry, they are entitled to have a family. Such right to marry and right to reproduce has been granted to both men and women equally, but when they have attained the age of marriage. Such marriage need to be made with free and full consent of the spouses, as mentioned in Article 23, Clause 3. So again the same requirement, full and free consent of both the spouses is required in the marriage. Again we can say that a person can give the free and full consent only when he or she attains the age of majority. That will mean that men and women who are below the age of majority, who are below the age of giving full and free consent, are not entitled to marry and to reproduce or to have the family. It also means that the men and women who are below the age of majority or the age of giving free and full consent should not be married, should not be expected to reproduce or to form the family. Article 23, Clause 4 of ICCPR imposes duty on the state parties to take necessary steps to ensure that spouses of marriage possess equal rights and responsibilities, not only during the continuation of marriage, but also at its dissolution. Then UN Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW 1979. CEDAW is considered to be the most significant international instrument with regard to the protection of the rights of women, with regard to the protection of the women against any kind of discrimination. Article 16, Clause 1 of this convention deals with the duty of state parties to take action to ensure equality in nuptial rights of men and women, including the right to choose a spouse, right to marry, and most importantly, right to have free and full consent in the marriage. So, every woman has the right to have free and full consent in the marriage. The marriage cannot be solemnized against the will or the wish of any woman. The marriage cannot be solemnized without the free and full consent of the woman, because each and every woman has the right to have free and full consent in the marriage. This against it also negates the practice of child marriage, because the child is not capable of giving free and full consent. Article 16 clause 2 of SIDA imposes duty on state parties to take necessary action to dictate a minimum age of marriage and to ensure that marriage or betrothal of a child should possess no legal effect and to take the registration of marriage as mandatory. Article 16 clause 2 states that this is the duty of the state parties, this is the duty of the member countries of SIDA to take necessary action to dictate a minimum age of marriage. This is the important point with regard to the protection of children from child marriage under the international mandate or under the international law. Though this is relating to, or this is with regard to the women only, the SIDA, because this convention was adopted to protect the women against any kind of discrimination. But that may be the indication that the minimum age should be fixed for both men and women, and particularly for women under Article 16(2) of SIDA, this duty has been imposed on the state parties, on the member parties, on the member countries to provide for or to fix the minimum age of marriage, so that the child marriages may be restricted, so that solemnization of child marriages should be avoided. Convention on the consent to marriage, minimum age for marriage and registration of marriage 1964. This convention was very unique convention. See, this convention is adopted specifically on the point of consent to marriage, minimum age and registration of marriage, only on three important issues, and all the three important issues are related to the marriage. And certainly, it is to address the problem of child marriage. Article 2 of this convention provides that state parties should take legislative action in order to mandate a minimum age of marriage. What does it mean? That all the state parties to this convention are obliged to provide for the legislation, to enact the legislation for providing for the minimum age. All the state parties are obliged to enact the legislations to prescribe the minimum age of marriage. Any marriage contracted in deficiency of such age should not possess legal effect unless any provision has been made for such exemption based on interest of spouses. This is also the duty of the state parties to make the law to declare any child marriage as ineffective, except the circumstances where it is in the interest of spouses. So, this is the duty which has been imposed on the member states of this convention or the state parties to enact the legislation to prescribe the minimum age, to declare that the marriages which are held, which are solemnized in contravention of the provision requiring the minimum age shall have no effect, with the exemption or with the exceptions, if any, are required with respect to the interest of the spouses. That means that in international law, the sufficient provisions have been made to deal with the problem of child marriage or to address the problem of child marriage, and the countries or the state parties to these conventions are obliged under this international mandate, under this international law, to develop their laws in accordance with the spirit of this international mandate and to restrict the child marriages in their territory. Now, we see the constitutional mandate in India. What are the constitutional provisions or what is the constitutional mandate with regard to the child marriage? As I told you that child marriage is also the abuse of childhood, it is the exploitation of the children, it is a neglect to the rights, basic rights of the children, and therefore, this matter also relates to the part 3 of Indian Constitution, that is the fundamental rights. We always refer Article 15 of the part 3 of Indian Constitution with regard to the authority of the state to make the special provisions in favor of or for the protection of the rights of the women and children. Again, we are referring this article of part 3, where the state is authorized under clause 3 of article 15 to make the special laws for the protection of women and children. It means the state is obliged under this constitutional mandate to make the laws to protect the children from child marriage or from the abuse of childhood by their parents if they solemnize the marriage of a child. Article 21 is very significant provision of Indian Constitution, conferring different kinds of rights on the persons. Right against exploitation, right against disrespect, right against indignity, these rights have been guaranteed by Article 21 of our Constitution. So, when the children or when every person has right to life and personal liberty, it means that every person has the right to choice of marriage, and therefore, the child marriage should be avoided because the children are not capable of making the free choice of marriage. Article 21A of Indian Constitution confers the right to education on the children. We know that this Article 21A has been included in the Constitution by way of 86th Constitutional Amendment in 2002, and by the inclusion of this article to the Constitution, the right to education has been declared to be fundamental right, has been recognized to be the fundamental right by the Indian Parliament, fundamental right of the children from 6 to 14 years. In pursuance to this constitutional mandate included in Article 21A, an enactment was passed by Indian Parliament in the name of Right to Free and Compulsory Education, 2009. When each and every children from 6 to 14 years age has right to free and compulsory education, then it imposes the obligation over the state to guarantee this right of children. Not only to guarantee this right of children, but to eradicate or to deal with any such hindrance or any such barrier which impedes the right to education of children under Article 21A and under right to free and compulsory education. This is the duty of the state, because the rights are enforced against the state. So, if anybody is deprived of his fundamental right, then it is the obligation, this is the duty of the state to make certain arrangements to provide for certain circumstances in which that right can be availed by the concerned individual. We know that the fundamental rights are certain circumstances which are needed or which are required for the full development of the personality of an individual. Right to education as the fundamental right under Article 21A is also such a right, such a condition, such a circumstance which is the condition precedent for the full development of the personality of a child. So, if any marriage is solemnized during this age or before the age of 14 with respect to Article 21A, then certainly this is the impediment of, this is the violation of the right to education under Article 21A, and that child has the remedy, has the right to enforce his or her right against the state. State again becomes responsible for providing for the remedy to such violation of fundamental rights. And therefore, we can understand that how this is the duty of the state or the government to restrict the child marriages for giving way to the fundamental right of education of the children. Article 39F, this directive principle of state policy was added by 42nd Amendment in the Constitution, and it says that a state should ensure protection of dignity of children for better childhood and youth. So, when the state is to ensure protection of dignity of children for better childhood and youth, then certainly the state is under the obligation to protect the children from the child marriages, because the child marriages are contrary to, violative of the dignity of the children. These are also violative of the rights relating to the childhood and youth. Article 45, Directive Principles of State Policy, provides for state action to ensure education to all children till they reach the age of 6 years. This provision was substituted by 86th Amendment in the Constitution. From 6 years to 14 years, now it is the fundamental right under 21A, and from 0 to 6, this is included in 45. Under Article 51A E, we owe the fundamental duty to renounce such practices which are derogatory to the dignity of women. Child marriages are certainly derogatory to the dignity of the woman, they are derogatory to the women, and therefore, the practices like child marriage should be renounced by the citizens of the country. Also, only the state is not responsible. It seems that in accordance with the constitutional mandate, not only the state, the citizens are also responsible to eradicate this social vice of the child marriages. Article 51AK again imposes the duty on each and every citizen of the country to take care of the childhood, duty on the parents or the guardian to provide opportunity for education for child in their care between the age of 6 to 14 years. So, the parents and guardians are responsible for providing the opportunities for education for a child in their care between 6 to 14 years. It is also being recommended by various corners, various legal scholars, that the amendment should be made in Article 21A and in Article 51AK also, to include those children who are below the age of 6 years. So, parents should not be responsible only for providing for the opportunities of education not only for the children from 6 to 14 years, but also the children from 0 to 6 years. Then what are the legislative initiatives in India with regard to the prohibition of the child marriage or with regard to the prevention of child marriage? In 2006, the Prohibition of Child Marriage Act 2006 was enacted. There was an old law, Child Marriage Restraint Act, that was enacted during the British period. Now, the Prohibition of Child Marriage Act 2006 has been enacted. The preamble of the Act prescribes that the Act is to deal with the prevention of child marriages and related matters. As per section 1(2), it applies to the whole of India and to all citizens residing in and outside India. Section 2(a) defines child as for male who have not attained the age of 21 years and for female have not attained the age of 18 years. Now, this is also 21 years. Section 2(b) defines child marriage as a marriage where either party is a child. Child marriage is a marriage whether either party is child. So, if any party to the marriage is child, then it is considered to be a child marriage. Section 3 of the Act prescribes that every child marriage solemnized before or after the commencement of this Act shall be voidable on the instance of party who was child at the time of child marriage. Section 3(1) says that every marriage solemnized before or after the commencement of this Act shall be voidable on the instance of the party who was child at the time of marriage. So, any such marriage is declared to be voidable under section 3 clause 1. Subsection 1. The petition for invalidating a child marriage is to be filed in the district court by the party to the marriage who was a child at the time of marriage. The proviso to section 3 subsection 1 says, who can file the petition seeking the invalidation of marriage? The party to the marriage who was child at the time of the marriage. Because on the instance of the party who was the child at the time of the marriage can be declared to be voidable under section 3 clause 1. But the petition for annulling the marriage can be filed by the party to the marriage who is minor through his or her guardian or next friend along with child marriage provision officers. If after getting the age of majority, the petition is to be filed, then the party to the marriage is to file the petition for declaring the marriage as voidable. But if during the age of minority, the petition is to be filed, then that petition can be filed through the guardian or the next friend along with the child marriage provision officer. Any child who is party to the marriage may file such a petition at any time, but before the completion of 2 years from attaining the age of majority. The petition can be filed at any time. Even during the age of minority, the petition for annulling the child marriage can be filed, but this petition is to be filed through the guardian, through the next friend along with the child marriage provision officer. If after gaining the majority, the party to the marriage files the petition for declaring the marriage as voidable, then this petition should be filed before the completion of 2 years from the date of getting the age of majority. So, maximum time of 2 years has been given to the party who was minor at the time of marriage to challenge this child marriage. The maximum 2 years time is prescribed. Any child who is the party to the marriage, see the section 3 subsection 4, the district court while granting the decree of nullity after giving show cause notice shall make an order to return the parties to marriage to their parents or guardians and to return any money or gift or an equal amount of such valuable received from the other party to him. So, parties shall be returned to the parents or the family, and if any money, any amount, any gifts were there, these are to be returned also. Section 4 deals with the maintenance relief could either lump sum or to be paid monthly and the residence to the female till her marriage by the male contracting party, and if he is minor, such maintenance will be provided by his parents and the guardian. So, section 4 deals with the maintenance relief, and this maintenance relief can be lump sum or it may be paid monthly. That relief may be also in the form of the residence facility to female till her marriage by the male contracting party. Male contracting party is liable to give the maintenance, to give the residence, and if he is minor, if the male counterpart or male contracting party is minor, then such a maintenance is to be paid or it should be given by the parents of the male contracting party. Section 5 provides for legal order for custody and maintenance of child born of child marriage by the district court, keeping in mind welfare of the child as the paramount consideration. So, if there is any matter of dispute, issue of custody or dispute of custody, then when the child marriage is dissolved, then the court is to make the order for the custody of the child, and the court at the time of making the order for the custody of the child should take into consideration as paramount consideration the interest of the child, welfare of the child. Section 6 renders legitimacy to any child conceived before the decree of the nullity, whether born before or after the act was enforced. This table shows the punishment for the offences relating to the child marriage. Section 9 of the Act, the offence is male adult marrying a child, then the rigorous imprisonment which may extend to 2 years or with the fine which may extend to 1 lakh rupees or with both. Section 10, the offence of performing, conducting, directing or awaiting a child marriage. The rigorous imprisonment which may extend to 2 years and with fine which may extend to 1 lakh rupees till the accused can prove that they had reason to believe that marriage was not a child marriage. This is the exception. Section 11 provides for the offence of promoting or permitting solemnization of a child marriage, and for this offence the punishment is the rigorous imprisonment which may extend to 2 years and with fine which may extend to 1 lakh rupees. No woman shall be punishable with the imprisonment for this offence. Then section 12 of the Act prescribes 3 scenarios when the marriage of minor shall be null and void. The marriage of a minor shall be, or a child marriage shall be void in 3 conditions which are provided by section 12 of the Act. Number 1, when the child is taken or enticed out of custody of a lawful guardian for the purpose of marriage. If the marriage has been solemnized after taking or enticed the child from the custody of the lawful guardian, then the marriage shall be void. Number 2, when the child marriage is solemnized by force or deceit the child was induced to move from any place. So, when by force or by deceit the child was induced to move from any place and the marriage was solemnized, then that marriage shall be void. When the child is sold for the marriage, when the child is trafficked for the marriage, when the child is used for immoral purposes. So, whenever the child is sold for marriage or in the pretense of marriage, in the name of marriage, if there is any trafficking of the child, is there is any immoral use of the child or there is the use of the child for immoral purposes, then the child marriage shall be void. These are the three conditions when the child marriage becomes void. Section 13 provides for the power of court to issue injunction to prohibit a child marriage on which complaint is made by someone having personal knowledge or by an NGO or anyone who have reasonable information on possibility of the child marriage. The power has been conferred on the court to issue injunction to prohibit the child marriage if on which complaint is made by someone having personal knowledge. If anybody who has the personal knowledge that a child marriage is going to be solemnized informs the court or any NGO or any person who have reasonable information that there is the possibility of child marriage, inform the court, then the court can issue the injunction. The child marriage and contravention of the interim or final order of the court issued under section 13 is held to be void ab initio by virtue of section 14. If the court issued the injunction for the prevention of any prospective child marriage and by non-compliance of this order, this direction of the court, injunction of the court, the child marriage is solemnized, such a child marriage shall be void ab initio. Void ab initio means that there had never been existence of this child marriage. It is considered, it is assumed. Then section 15 says that an offence punishable under this act shall be cognizable and non-bailable. The offence committed under this act shall be cognizable offence and it shall be non-bailable offence. Section 21 provides that this act repeals the Child Marriage Restraint Act 1929. So, the present act replaces the Child Marriage Restraint Act 1929. Hindu Marriage Act 1955 also prevents the child marriages, because under section 5(3) the age of the marriage has been prescribed, that is 21 for the bridegroom and 18 for the brides. It means that Hindu Marriage Act prohibits the child marriage. Indian Penal Code 1986, which is now Bharatiya Nyaya Sanhita, if we see exception 2 of section 375 IPC, now it is exception 2 of section 63 of Bharatiya Nyaya Sanhita, it says that sexual intercourse with his own wife who is below the age of 15 years is rape, and it is punishable under section 376 with the rigorous imprisonment of either description for a term which shall not be less than 10 years, but which may extend to the imprisonment for life and shall also be liable to fine. So, any such sexual intercourse with his own wife who is below age of 15 years shall be considered to be the rape under 376. But the exception 2 was held unconstitutional in the case of Independent Thought versus Union of India by the Supreme Court. The court observes that we must not and cannot forget the existence of Article 21 of the Constitution, which gives a fundamental right to a girl child to live a life of dignity. The documentary material placed before us clearly suggests that an early marriage takes away the self esteem and confidence of the girl child and subjects her in a sense to sexual abuse. Under no circumstances can it be said that such a girl child lives life of dignity. The right of a girl child to maintain her bodily integrity is effectively destroyed by a traditional practice sanctified by the Indian Penal Code. Her husband, for the purposes of section 375 of the Indian Penal Code, effectively has full control over the body and can subject her to sexual intercourse without her consent or without her willingness, since such an activity would not be rape. Although her husband can rape her, but he cannot molest her, for if he does so, he could be punished under the provisions of the Indian Penal Code. This was recognized by LIC in its 172nd Law Commission of India 172nd report, but was not commented upon. It appears therefore that different and irrational standards have been laid down for the treatment of the girl child by her husband, and it is necessary to harmonize the provisions of various statutes and also harmonize different provisions of the Indian Penal Code. Inter se. So, the opinion of the court seems against the solemnization of the child marriages. If we see the judicial approach, Neetu Singh versus State 1999, the Delhi High Court held that with regard to Hindu Marriage Act 1955, child marriage is neither void nor voidable, but punishable. Sushila versus State of Rajasthan 1995, Rajasthan High Court. The Rajasthan High Court, taking into account the menace of child marriage, directed the state to take necessary action against everyone involved in the child marriage and bring them before law with imposing penalty. The Leela Gupta versus Lakshmi Narayan, which was decided in 1978, the Supreme Court held that marriages in violation of section 5 subsection 3 of Hindu Marriage Act 1955 does not render the marriage void, and the widow have the right to inherit the property of deceased husband. This is the judicial approach with regard to the child marriage. It seems that the judiciary has been hesitant to declare the child marriages as void because of some social reasons, but at the same time the judicial approach seems to be against the solemnization of the child marriage. Certain enactments have been made in India, the international mandate is also available, and therefore the social initiative should also be taken to teach and educate the parents and the children both, so that we can save our children from the vice of child marriages, because the child marriages are certainly the barrier in the path of the education and development of the children. Thank you very much.